basically what you are saying is that our current law is diametrically opposite to the restatement. The restatement essentially says that we will recognize easement by necessity unless where it is perfectly clear that that was not the intent, and you say that our law is that we should not recognize it unless it is perfectly clear that that was the intent.
I think that, I mean, there is a lot of the common law that is in accord with the restatement. They both, both the common law and the restatement require unity of title. They require that the necessity arise at the time of the severance. So the sort of the basics of it, we all agree on. Where we part company is the common law of Massachusetts has been very clear in making it hard to create off-record rights, I would respectfully suggest, for very good policy reasons.
In 1878.
So what's the point of creating all of these landlocked lots?
It was created pursuant to a petition to the probate court.
What's the point?
The point was so that people could have ownership of their single house lots.
But couldn't get access to them?
They could get to them because at the time, no,
Yep.
excuse me?
Helicopters?
No, at the time of these conveyances, and the land court judge recognized this, found this as a fact, at the time of these conveyances, it was common practice and custom to allow free right of access over the land of other tribe members.
Seems so counterintuitive that you have this right of access under a common custom that we presume is the case, but that the amicus brief on behalf of the indigenous people themselves say is not common, that they have that, and because of the structure of the way the property was transferred, it can't be recognized any longer because it doesn't fit within our construct of how these kinds of easements are created. Maybe it just needs a new construct if it doesn't fit, because it doesn't seem to.
In 1878.
Can I just ask, when we talk about the parties and the party's intent, who are we talking about in terms of the party on the grantor side? Is it the Commonwealth?
Well,
is it the commissioner? Whose intent are we looking at?
That's a very good question, Your Honor. And obviously the enabling legislation was the Massachusetts Legislature that acted to essentially create the town of Aquinnah and to provide a means by which the inhabitants could petition the probate court. The probate court would appoint commissioners.
Can I ask you, how do you characterize this type of tribal access in terms of the common law? Was it something that was analogous to a personal right of access versus an easement in gross? Why doesn't it continue to exist even after the federal extinguishing?
I am not certain whether I would characterize it as a personal right or an easement in gross, but I would also suggest to you that I'm not sure that it was ever raised or ever argued that there was no right of access on foot by tribal members to reach these lots. That was not examined
But I mean,
below.
they may have needed a cart, they may have needed a
Certainly.
donkey or a horse or something like that, and so we've replaced all those things with cars.
And I understand that point.
And is it the commissioner's intent we need to discern, or were the commissioners acting as fiduciaries on behalf of the tribe?
I think the commissioners were acting as fiduciaries on behalf of the legislature because they were charged by the legislature with doing the setup.
But who owned the land? But it was owned by the town at that time.
It was owned by
correct?
the town at that point. Absolutely.
And the town agreed to the partition.
Pardon?
The town agreed to the partition.
The town had no choice but to agree to partition because the 1870 legislation mandated it. That's simply not an acceptable result. The plaintiffs argue that they're one lot. Well, look, we're one lot away.
I'm sorry, it's not acceptable because it produces some uncertainty, I understand, but I mean, wouldn't the land court identify what would be an appropriate easement, which would be respectful of the property rights of those whose property is being burdened?
Well, in effect, you're wiping out 140 years of real estate activity in the town. and creating a cloud of title on every lot in the town.
How long would that cloud last? It would last until the land court resolved it, wouldn't it?
No, because the land court is only dealing with these two parties. This decision, if you come down again, you know, if you don't reverse the land court, you're subjecting every parcel of land, and registered or unregistered, I'll go back to it, every registered or unregistered, to a potential of having a road located on his property. These plaintiffs are only two. This case would have implications throughout the entire
tribe. That's because this statutory scheme was part of a historic effort to restore long disenfranchised people whose land had been expropriated from them with no participation by them except violence, to try to restore them to the status of humans and citizens in this country. The fact that the intention was to create alienable lots, and by the way, that was the intention of the legislature here. This court in 1871, in Danzell versus Webquish, 108 Mass at 134, clearly stated that the purpose of these statutes was to allow the Native American people to alienate land. That was considered a fundamental part of the bundle of rights of citizenry that was being created here, the right to alienate land. The law of easements by necessity is based on the common sense, logical proposition that where parties divide up one solid piece of land, they intend the grantees to have a legal right of access. That's what you need to alienate property, and that's what these Indians needed in order to alienate these otherwise landlocked lots. They needed a legal right of access. They didn't need permissive use that couldn't be transferred to anybody outside the tribe.
Those lots were conveyed over the years, since 1878, to non-tribal members.
Well, how many that is not in the record, and I don't.
Well, yes, but I mean, you know, it's sort of like this big gaping hole in the record too. You know, I mean, what happened to the land in that period of time, and how is it possible that no one who bought the land wanted to know about this easement? How do they get access to these lots?
The development of this area is pretty complicated, but you know, the Moship Trail got put through, so that gave people who didn't have access before easement. Another road got put through, that gave people access. Many of the owners were very, very poor, who couldn't afford to litigate this issue. By the way, the law of the restatement is not grounded largely in public policy. It's grounded on that common sense proposition that people don't intend to create landlocked parcels. So, and that's what the restatement says. It's very clear. The other two propositions that are common sense is that the legislators, with explicit intent to create alienable parcels for these formerly disenfranchised people, did not intend to give them landlocked lots. That would have been brutal. That would have been one more insult on the history of this country. That's common sense proposition number 2. And common sense proposition number 3 is that the people who petitioned to turn their common land into a bunch of parcels, looking for the protection of the common law title, which they'd never had before, somehow didn't intend that they would have common law access. That makes no sense. So rule of law is not to speculate what was in people's minds. You need clear evidence that they intended there be no legal right of access. That's the law of Massachusetts, Davis versus Sykes, and that's the law of the restatement. There has to be clear evidence that no access was intended. And the case in Massachusetts that's about that is Orpin versus Morrison, which has all the bedrock law, except for in that case, there was evidence that the parties said to each other, we're not gonna have any access here. That's clear evidence. That satisfies the restatement's rule. This is such a powerful rule of law throughout the centuries that this court and other
Statement rule or our common law?
both. This rule of law is so powerful over the centuries that it trumps a warranty deed. It is a powerful appurtenant right that is created the minute the transaction happens and an otherwise landlocked parcel is created, and it runs with the land. It's a powerful, logical, fair rule of law that no one has had the resources until now to try to actually stand up and fight for.